Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Amiera, Atrisyia Binti Amir. My tick number is 1231533. Today I'll be presenting about the sources of international law under Article 38 subsection 1 of the Statute of the International Court of Justice, or we known as ICJ. The sources of international law refer to the origins or the foundations from which international rules are created and identified. They will tell us where international law comes from and how it legally binding or how it legally applied. So under Article 38 subsection 1 is important because it guides the ICJ on what materials it should when deciding case. What materials we should use when we want to decide in case. So there are a few sources. For the first one is the most authoritative sources is treaties. Treaty is a written agreement between states that sets out their legal rights and obligations. Treaties are binding only on the countries that have consented to them, usually through ratification. So for example, United Nations. In United Nations, we have the Charter of the United Nations 1945, and another one is the Paris Agreement 2015 on climate change. So treaties can cover almost any topic, from human rights to trade and even space exploration. So once a state signs to a treaty and ratifies a treaty, it will be legally bound to follow its terms under principle of pacta sunt servanda, meaning that agreement must be kept. So another sources is customary international law. In this customary international law, unlike treaties, customary is not written because they develop through the consistent and general practice of states and combined with their belief that such practice is legally required. It can be known as a concept we call as opinio juris. So for instance, the prohibition of genocide and the principle of diplomatic immunity exists as a customary law because almost every country follows and accept them as a legally binding even without a specific treaty they consent to. So customary law is essential because it fills gaps where treaties do not exist and apply to all states, not only to those who sign to the specific treaties. So another one is the general principles of law. General principles of law recognized by civilized nations because these are the fundamental principles that common to the world's major legal system because they ensure fairness and help courts decide case when there is no specific treaty or custom available. For example, the principle of good faith, equity, fairness in judgment, and the last one is no one should be a judge in their own cause. We call as nemo judex and causa sua. So these principles are like the moral backbone of international law that helps the ICJ to interpret and apply justice in a balanced way. So let's move on to the another sources that does not create law on their own, but they help to interpret and also they apply existing rules. For the first one is judicial decision. Judicial decision is judgments or advisory opinions of international courts or any tribunals such as the ICJ, ICC, International Criminal Court, and regional courts like the European courts on human rights. So although these decisions are not binding precedents, they are highly persuasive and often used as a reference for future cases because they help to clarify how the rules or treaties or customs should be understood in real life situation. So in other sources is writings of publicists. So the famous writers are Abdul Ghafur Hamid that analyze and interpret the law that helps judges and lawyers and also law students to understand a very complex legal question. So while their writings are not binding, they play a supportive and interpretative role, especially when the law is unclear. So usually the writings of publicists are the works of respected legal scholars and experts in international law. So we go to the cases that demonstrate how the sources are applied. So for the first one is North Sea continental shelf case in 1969. So in this case, Germany, Denmark and Netherlands disagreed over how to divide the continental shelf in the North Sea, because the ICJ had to decide whether a particular rule in the Geneva Convention on the Continental Shelf 1958 had become part of the customary international law. So the court ruled that it had not yet become a custom because not enough states practiced it and there was no clear evidence of open juries. So this case showed that for a custom to exist, both consistent practice and legal belief are required. So another case is Nicaragua and United States, 1986. In this case, Nicaragua accused the United States of supporting armed rebels and violating its sovereignty. Even though the US had withdrawn from the relevant treaty, the ICJ found that the principle of non-use of force was part of customary international law. So the court emphasized that custom can operate independently of treaties, and proving that states are still bound by general international rules even when they are not treaty members. If I'm not mistaken, Nicaragua against United States, 1986. So to summarize or to sum up, Article 38 subsection 1 of the ICJ statute identifies the main sources of international law as treaties, customary law and general principle of law, judicial decision and scholar writings. So together they ensure the international law, both in writing and evolving, binding yet flexible and capable of guiding global relations in a fair and consistent way. So understanding these sources help us see how international law is created and how international law is applied and interpreted in real cases. Thank you very much for listening. Assalamualaikum.